895 F Sup 831, Eastern District of Virginia, 1995, where Judge Ellis, a legendary jurist known by all Virginia practitioners, held that, quote, a law firm attorney working with a client is nonetheless an independent contractor and is not an employee of the client corporation. In that case, the employer was a corporation, but the same logic applies when it's an individual like Mr. Depp. That was Mr. Waldman's role. Indeed, clients hire lawyers to obtain specific results, or to try to obtain specific results, but they do not control the means by which the results are accomplished. Lawyers, as Your Honor has reminded us, are subject to professional obligations to exercise independent professional judgment. We are not at the whim of our clients as much as we want to serve them. See Virginia State Bar Professional Guidelines, Rule 1:2 and 2.1. And just to quote 2.1, in representing a client, a lawyer shall exercise independent professional judgment, unquote. Mr. Waldman is, as a matter of law, an independent contractor, and Mr. Depp cannot be held responsible for any alleged tort by his attorney, particularly for statements about which he was unaware until he was sued for them. Mr. Waldman testified, and it's unrebutted, that he has his own law firm. He's not an employee of Mr. Depp. Mr. Depp or none of his loan-out companies have issued him a W-2, and Mr. Waldman provides legal services to clients other than and in addition to Mr. Depp, and that's found at the transcript, page 6020 through 21. All of that is unrebutted by Ms. Hurd. Mr. Waldman's statements, the third reason for which we respectfully submit the counterclaim should be stricken, is that Mr. Waldman's statements were protected opinion. And I won't run through all of that, but very briefly, taken in their proper context, the counterclaim statements are non-actionable expressions of opinion entitled to protection under the First Amendment. See Gertz versus Robert Welchink, 418 U.S. 323 at 339. That's a 1974 case from the United States Supreme Court. See also Shacker v. Bufault, a Virginia Supreme Court case found at 290 Virginia 83, a 2015 case, noting that where, quote, all sides of the issue, as well as the rationale for the speaker's view were exposed, the assertion of deceit reasonably could be understood only as the speaker's personal conclusion, unquote, and finding an accusation of deceit to be opinion. In context, Your Honor, any reporter or any reasonable reader would understand and expect a lawyer associated with Mr. Depp, as Mr. Waldman was, to challenge Ms. Hurd's version of the inherently controversial events of the parties' marriage. Just as Ms. Hurd's lawyers were quoted challenging Mr. Depp, and Your Honor will remember the context of these quotes that were in a British tabloid where Mr. Waldman's statements were buried well into article in which both points of view were clearly expressed, and Mr. Waldman was clearly identified not as an independent expert on the U.S. Constitution, but as one of Mr. Depp's attorneys. C. Chavez, 230 Virginia 112 at page 119, quote, the most unsophisticated recipient of such a claim, i.e. any reader of the British tabloid, made by a competitor against another could only regard it as a relative statement of opinion grounded upon the speaker's obvious bias, unquote. Mr. Waldman has never did anything to hide his support and belief in Mr. Depp. Finally, Your Honor, and for the rest, ultimately, Mr. Waldman's statements reflect the existence of two competing narratives and are merely his subjective view about events that he never claims to have witnessed, and there was no doubt about that. Turning to the second part of the argument, which will be more abridged, Ms. Heard is not entitled to anti-SLAPP immunity. As a threshold matter, Virginia Code Section 8.01-223.2, which is, as Your Honor well knows, is the Virginia anti-SLAPP statute amended most recently in 2019, provides in relevant part, quote, the immunity provided by this section shall not apply to any statements made with actual or constructive knowledge that they are false or with reckless disregard for whether they are false. Here, in addition to Mr. Depp's testimony, several witnesses have testified that A, they never witnessed Mr. Depp abuse Ms. Heard, and B, that they observed Ms. Heard without any injuries, marks, bruising, swelling, etc., during periods when Ms. Heard claimed to have injuries, marks, bruises, etc. Such witnesses include, but are not limited to, Isaac Baruch, Kate James, Dr. David Kipper, Nurse Debbie Lloyd, Officer Sines and Haddon, Officer William Gatlin, and former U.S. Marine Starling Jenkins. Ms. Heard's request for anti-SLAPP immunity should be stricken, and even if there were disputed facts as to that, the anti-SLAPP immunity does not apply because the defamatory implication of Ms. Heard's statements are not solely relating to a matter of public concern as is required under the statute. As has become quite clear, Your Honor, Mr. Depp is not suing about any of the public policy commentary made by the ACLU when it drafted the op-ed, and Ms. Heard put her name to it. What he is suing about here are the three statements that were directed at him. He has no issue with women's rights. He supports women's rights. In fact, he was the one, Your Honor, as Your Honor knows, who made that first $100,000 contribution to the ACLU, and he made it also to the CHLA.
Your Honor, at this point, I'm going to object. Mr. Chu has largely just read his brief and confined his arguments to those directed in the motion, but like we saw with the last motion to strike, he's now directing his arguments to something other than what's at issue here, and I would object because I think making an argument not to you but to the cameras, it's disrespectful to the court and to everyone's time, and it also threatens to undermine the integrity of this process and risk the jury being influenced by outside factors.
Well, it's his argument. I'll allow him to do his
Thank you.
Thank you.
Thank you, Your Honor. As I was trying to say, what Mr. Depp is suing about are the three statements. And it's very clear, despite the pious opening statement that about the First Amendment, that with the testimony of Terrence Doherty and the emails that were admitted as exhibits, that the ACLU and Ms. Heard were conspiring to make it very clear that those three statements were related to Mr. Depp, because otherwise nobody had any interest in the article. And it's crystal clear from that. They wanted to time this thing with the release of Aquaman, which was her first film of any significance in terms of popularity, and to do that. That's very clear. So the charade that this had something to do with public policy is risible, and that is not why the anti-SLAPP protections were enacted. They were enacted to protect the rest of the article, not what Mr. Depp is suing about. As generally analyzed by the courts, a matter of public concern is one which relates to, quote, a matter of political, social, or other concern to the community, unquote, as opposed to a matter of only, quote, personal interest, unquote. That's Connick versus Myers, 461 U.S. 138 at page 146. Instead, the defamatory implication at issue in each of the three statements at bar relate to the personal grievances between Mr. Depp and Ms. Heard, which does not rise to the level of a matter of public concern with broader implications for society beyond the two litigants in this action any more than Mr. Waldman's statements. I mean, adding the gloss of public policy might immunize the statements that relate to public policy, but those are not at issue here. Mr. Depp agrees with those statements. We're talking about the three statements that they very intentionally and very cleverly put in to make it clear the implication that it was about Mr. Depp. They had lawyers from the ACLU working around the clock with Eric George to be as clever about this as possible. And Your Honor remembers the testimony of Mr. Doherty about the consternation at the ACLU when they realized that USA Today and everybody else who read the article knew darn well that this was about Mr. Depp. This cannot be protected by the anti-SLAPP statute. It is a cynical runaround. And I think now that we have the undisputed evidence from the ACLU in the form of the testimony of Terrence Doherty, who is not only their corporate representative, he was their general counsel. He is a brainiac lawyer. They knew exactly what they were doing, Your Honor. And he referred to testimony of a woman at the ACLU who said she had nightmares about Ms. Heard, and he expressed no concern about that. Now, that was either because they knew about, that was either a reference to this game they were playing with the op-ed or the conspiracy they had to cover up her failure to make the donations. The donations became pledges, but we have evidence that she refused to sign the pledge card. So she's caught either way. Simply stated, Your Honor, Mr. Depp is not suing Ms. Heard for making statements about society in general. I think that's very clear from the record evidence. Mr. Depp is suing her for publicly naming him as an abuser by implication and forever tarnishing his good name, an act that, coming from an ex-spouse, is fundamentally personal in nature. For that reason as well, Your Honor, Virginia's anti-SLAPP statute is not applicable. And based on the foregoing, Your Honor, Mr. Depp respectfully submits that the court should grant plaintiff's motion to strike the counterclaims and also strike her claim that she is immune under the anti-SLAPP statute. Thank you very much, Your Honor.
Thank you, sir. Yes, sir.
Thank you, Your Honor. As Your Honor knows, the trial court is required to accept as true all the evidence favorable to Amber at this point, as well as any reasonable inference a jury might draw therefrom which would sustain the counterclaim. That's the correct standard here. I'll address the actual malice argument first, the agency argument. Your Honor, there's plenty of evidence in the record from which the jury could determine that Mr. Waldman was Mr. Depp's agent. He made those statements. The statements referred to him as Mr. Depp's attorney. As Your Honor ruled on Friday with respect to the jury instruction conference, an attorney is an agent of his client. Mr. Waldman testified that he's been Mr. Depp's attorney since 2016. He freely admitted speaking to the press on Mr. Depp's behalf, and he refused to answer question after question about that agency, so we can't use that as a sword now. Mr. Chu puts a lot of emphasis on the fact that Mr. Depp allegedly didn't see the comments that were made that are the subject of the counterclaim, but as Your Honor well knows, whether he saw them or not is not the standard for agency. There's also evidence that Mr. Depp met with the Daily Mail with Mr. Waldman prior to the defamatory statements being made and released. I believe that was in February of 2020, just 2 months prior. Mr. Waldman also concocted a story that Amber was being investigated for perjury by filing a perjury complaint against her with the LAPD. He disregarded any evidence that he didn't believe would fit in his narrative, that would fit in this story that he was speaking about on behalf of Mr. Depp. And after Mr. Depp lost the UK proceeding, after Mr. Depp was ruled to be a wife beater by the court in the UK proceeding, the court there found him to be a wife beater. Mr. Waldman then got an overseas tabloid to run a story claiming that Amber was being investigated for perjury, which simply wasn't true. He walked into the LAPD, filed a complaint for perjury against Ms. Heard, found a media outlet that doesn't follow the two-source rule, and then he had let the world believe that the LAPD was investigating Ms. Heard for perjury. That's a shameful and a sickening example, Your Honor, of the lengths that Mr. Depp, through his agent, Mr. Waldman, would go to smear and to defame Amber Heard, and that continued in the 3 statements in the counterclaim. Your Honor has heard evidence, I won't go through all the evidence, but Your Honor has heard evidence from Ron Schnell, who's traced the negative hashtags toward Amber Heard online associated with those defamatory statements, and noted the staggeringly high number of them that were associated with Mr. Waldman. Under the principles of the agent-principal relationship in Virginia, Your Honor, when Mr. Waldman made those statements, he was standing in the shoes of Mr. Depp. They are one and the same for the purposes of those statements. As Your Honor discussed at length on Friday, Mr. Waldman made these statements with actual malice. There's plenty of evidence from which the jury could infer that, and his own, both from the actual malice from Mr. Depp and Mr. Waldman's own reckless disregard of facts that didn't support Mr. Depp, and his attempts to manufacture false evidence that did. As Your Honor found in the hearing, I believe it was on March 24th, after Your Honor denied Mr. Depp's motion for summary judgment, Your Honor said, as to malice, a fact finder could reasonably conclude that Mr. Waldman made the statements with malice because Mr. Waldman has no personal knowledge of the party's marriage and still made the statements at issue. Nothing in this case has changed that. If anything, the evidence has only made it more clear that that is an inference that the jury can and we believe will find. So, Your Honor, there's no basis to grant a motion to strike on this agency argument, on the actual malice argument. The evidence shows that not only was Mr. Waldman Mr. Depp's agent, but that the two of them conspired to falsely accuse Amber of creating a hoax and falsify evidence that they believed supported their theory and what they wanted to achieve. As Your Honor well knows, too, I won't go through all the law, but both agency and malice can be inferred through circumstantial evidence. There's plenty of evidence in the record from which the jury could infer those. Moving on, Your Honor, to the independent contractor, the court's already rejected this argument, ruled that an attorney-client have a principal-agent relationship, and as Your Honor said on Friday, there's no evidence in this case of anything otherwise. As to the argument that the counterclaim statements are statements of opinion, the court has already found twice that they are not statements of opinion, both on January 4th, 2021, in its opinion letter denying Mr. Depp's demur as to the counterclaim statements, and at the motion for summary judgment hearing in March of this year. As the anti-SLAPP argument, the court again has already ruled at the March 24th, 2021 opinion that the statements are, as a matter of law, regarding matters of public opinion. The court has already ruled that. Therefore, the only remaining issue for anti-SLAPP is whether the intent element of immunity is met. As we discussed on Friday, the intent element of immunity is substantially the same as the actual malice standard, which the evidence in this case easily allows the jury to find in favor of Ms. Heard on that. I won't go through the litany of evidence that supports that Mr. Depp is an abuser here, but I'll touch on a few things that relate to Mr. Chu's argument. One, Mr. Chu was totally misrepresenting Mr. Doherty's testimony. There's not a single piece of evidence, Your Honor, in this case suggesting that Ms. Heard and the ACLU were somehow conspiring to achieve a defamatory implication to Mr. Depp. That's simply not what Mr. Doherty said. Mr. Chu's feel free to argue that to the jury, but that's not what his testimony reflects. Your Honor, there's also plenty of evidence that's been adduced both in Mr. Depp's claim and in Ms. Heard's counterclaim that show that absolutely that the counterclaim statements are 100% false. There was no hoax perpetrated. Mr. Depp is an abuser who abused Ms. Heard. She did not conspire with her friends to create a hoax. She did not create a hoax herself. And just very briefly, some of the evidence that's come up since the last motion to strike, Your Honor, that Mr. Chu conveniently disregards in his brief are the testimony of Rocky Pennington, the testimony of Josh Drew, the testimony of Elizabeth Mars, all of whom completely corroborate Ms. Heard's account of the events of May 21st, 2016. The testimony of Melanie Iglesias, who testified that she covered Ms. Heard's bruises with makeup right after the December 15th incident, that provided ample testimony to support that Ms. Heard often would cover her bruises that were caused by the plaintiff, in this case, by Mr. Depp, with makeup. He ignores the evidence of Christy Sexton. He ignores the evidence of Io Tillett Wright. He ignores the evidence of Whitney Enriquez. All of these witnesses and others have testified extensively about Mr. Depp's abusive behavior toward Ms. Heard. Physical abuse, emotional abuse, psychological abuse, verbal abuse, Your Honor. Mr. Depp's own writings, recordings, pictures, and videos confirm that. The list goes on. There's abundant evidence in the record, Your Honor, from which the jury could, and again, we believe will find that Ms. Heard is not liable for defamation to Mr. Depp, and therefore, by definition, she has not acted with actual malice, and based on the court's rulings on March 24th, 2021, she would be entitled to anti-SLAPP immunity, which would permit her to ask the court to award attorney's fees against Mr. Depp. So with that, Your Honor, I'm happy to answer any questions the court has.
That's
but
fine.
that
Thank you,
covers
sir.
it. Thank you.
All right. Yes, sir?
Your Honor, I will be brief in deference to the court's time and the jury's time. What Mr. Rottenborn said about Mr. Waldman's allegedly going to the LAPD about perjury is a complete non sequitur. If they thought that that were somehow improper conduct, they could have included it in their counterclaims. They included everything else but the kitchen sink, and most of it was thrown out. There was nothing in there about Mr. Waldman going to the LAPD. So that is a very clear non sequitur red herring distraction. Number two, when Your Honor ruled on summary judgment on the issue of the counterclaims, Your Honor was dealing with a different standard and a different evidentiary record. At that time, Mr. Waldman had not testified, which is material. Mr. Waldman has now testified for purposes of trial. We have his trial testimony. It's very clear that he did not act with actual malice. They didn't even argue that. So that's pretty clear. And again, this is consistent. The third point is that it's all about games. They didn't sue Mr. Waldman on the three statements. They didn't try to fill the hole. They've been telling us for a week that they're going to call Mr. Depp to try to fill the hole in their counterclaims. They didn't do that. And it's very consistent with the game playing. Let's go into court after the police have found no problem and after witness who had no relationship with each other said there are no visible marks. Let's not give Mr. Depp's lawyer the required 24-hour notice before the TRO. Let's march into court with our publicist, with our lawyer, with our best friend who no longer talks to her. Let's get a TRO. And when the Me Too folks say, why are you taking $7 million from an abuser? They said, I didn't take money from the abuser. I gave it all to charity. Well, they didn't. I don't think anybody should feel bad about them stiffing the ACLU, given what the ACLU did in this case, which is a monstrosity. But she did stiff the sick and dying children. It is gamesmanship, and that's what she's doing here today. But the law is the law, and they have not fulfilled their burden with respect to the counterclaims. There is virtually no nexus between Mr. Depp and Mr. Waldman as to these statements at issue, except for the fact that he is an attorney, and that is not sufficient in a case where they have not even established that Mr. Depp was aware of these statements. And they knew that they couldn't do it, and they didn't even try. And it's more of the gamesmanship when Ms. Heard plays word games with Mr. Depp about, oh, I didn't punch you, Johnny, I just hit you. Imagine if the shoe were on the other foot and Mr. Depp, a man, was saying to a woman, oh, woman up, I only hit you, I didn't punch you. And when it was chilling, when she warned him on the tape, you go tell a judge, you go tell a jury that you, a man, were abused. See if they're going to believe that. It is an abuse of the system, and she's done it throughout. Finally, Your Honor, and Mr. Rottenborn makes an excellent point with which I agree, which was that with respect to each of the three statements, Mr. Waldman was clearly identified, even by the tabloid that printed these, well within articles that had both sides represented, that he was Mr. Waldman's attorney. Even the reader of a tabloid understands that when you're getting statements from attorneys, it's going to be forwarding their client's point of view. Mr. Waldman is not the only attorney who has spoken out. Robbie Kaplan, who was Ms. Heard's second attorney. So Ms. Heard started out with Eric George. He made comments to the press.
Objection, Your Honor. Again, this is so much further beyond what Your Honor is addressing.
I'm finishing up, Your Honor.
Okay.
I'm finishing up. My point, Your Honor, and it's on point, is that Mr. George made statements supporting Ms. Heard's position. Ms. Kaplan made very clear statements supporting her client's position on the merits, and so did Mr. Waldman. But everybody knows when reading those that those are statements by partisans. So for the reasons that we've stated and the reasons set forth in the brief, we respectfully submit that the court should grant the motion to strike, or in light of the fact that Mr. Depp may reappear, at the very least, take these motions under advisement until the close of all evidence. Thank you, Your Honor.
All right, thank you, sir. All right, in this matter, I've reviewed all the defendant's evidence as to her counterclaim, and I've considered the arguments of her counsel and plaintiff's counsel. First, to address a few issues that I believe are outside the motion to strike, and that's as to the slap defense. The slap defense is just that, it's a defense, so it's really not considered in a motion to strike. Having said that, we went down that legal road on Friday as far as the slap defense goes, as far as the jury instructions. In this particular case, if the plaintiff prevails, it must be with actual malice. Therefore, if it's with actual malice, immunity does not apply under that statute. So we will deal with that with jury instructions, and we have. As to independent contractor, again, I think it's outside the motion to strike. However, Mr. Waldman was plaintiff's attorney since 2016. Before the initiation of litigation, there is evidence that Mr. Waldman had a certain role during the prior divorce proceedings in the UK case. Additionally, there is evidence that shows his legal representation was broader than just a limited litigation, as outlined in all the cases presenting an attorney as an independent contractor. So the only evidence in this case to this point is that Mr. Waldman was an agent to Mr. Depp, and that is the basis to weigh the motion to strike. As far as the opinions argument, again, I think that is outside the motion to strike. The opinions argument, the court has already ruled on this matter as to the three statements that are at issue in the counterclaim, ruled that they were not opinion at the demur and at summary judgment. So that argument will not be part of the motion to strike. So when assessing a motion to strike, the court accepts the favorable evidence adduced as true towards the non-moving party. The court cannot reject any inference from the evidence favorable to the non-moving party unless it would defy logic and common sense. When there is any doubt and question, the court should overrule a motion to strike. Agency may be inferred from the conduct of the parties and from surrounding facts and circumstances. When there is no direct evidence, circumstances may, and usually are, relied upon to determine whether an agency relationship exists. A principal is liable for the tortious acts of his agent if the agent was performing his principal's business and acting within the scope of his agency. If an agent's tortious act arises from their agency relationship, is enacted in part to service the principal can be held liable for the tort. Here, the alleged tort is defamation. Besides demonstrating the agency relationship, the defendant must prove Mr. Waldman published an actionable statement, meaning a statement that is both false and defamatory, with the requisite intent. As to agency, Mr. Waldman was plaintiff's attorney at the time of the alleged defamatory statements were made. Mr. Waldman does not deny this, and neither does the plaintiff. Moreover, Mr. Waldman made the allegedly defamatory statements about the defendant during the proceedings of this action and interacted with the defendant once the statements were made while still representing the plaintiff. Taking the surrounding circumstances as a whole, an agency relationship can be inferred, and thus a scintilla of evidence regarding agency must be turned over to the jury. In addition, the jury may infer that Mr. Waldman made these specific statements to a third party to service plaintiff by portraying defendant as an opposing litigant in a negative light. It is not disputed that Mr. Waldman published statements and that there is a question as to whether statements are false, and both parties disagree and have presented conflicting evidence as such. As to actual malice, Mr. Waldman made the counterclaim statements after he met with his client. In addition, there is evidence the plaintiff was with Mr. Waldman at a meeting in February 2020 with the Daily Mail Online. Further, defendant claimed that she met with Mr. Waldman where he threw the paper containing the counterclaim statements within them. Consequently, there is more than a scintilla of evidence that a reasonable juror may infer Mr. Waldman made the counterclaim statements while realizing they were false or with a reckless disregard for their truth. It is not my role to measure the veracity or weight of the evidence. The Fourth Circuit and the Virginia Supreme Court have made it crystal clear that actual malice is a question for the fact finder. So therefore, the plaintiff's motion to strike is denied. Okay? Thank you. Is there any other preliminary matters before the jury?
Yes, Your Honor.
Okay. right, are we ready for the jury then? Yes, ma'am. Okay. Good morning, ladies and gentlemen. I apologize, we had a few housekeeping matters to take care of, but thank you. You can have your seat. All right, your next witness.
Your Honor, on behalf of defendant and counterclaimant Amber Heard, we rest.
All right, thank you. All right, rebuttal evidence?
Yes, Your Honor, Mr. Depp calls Walter Hamada of Warner Brothers.
All right, Mr. Hamada.
Your Honor, just to clarify, this is by deposition, so we may need
Oh,
that.
okay, well, okay.
I apologize, I should have provided notice.
That's all right.
Thank you, Your Honor.
If we could get the, yeah.
Hamada, what do you work for Warner Brothers Entertainment Inc.?
Yes, I do.
In what capacity?
My title is President of DC-based film productions for Warner Brothers.
What, if anything, you did to prepare to testify for Warner Brothers as to topics 2 through 18?
I did not do anything to prepare for this, other than the meeting that I had with the attorneys.
Did Warner Brothers have a contract with Amber Heard to perform in Aquaman 2?
Yes, there was we had an option agreement for her for Aquaman 2.
Do you know what it is?
It looks like a standard contract between an actor and the studio.
And which actor was involved in this? Which actor was a party to this contract?
Amber Heard. It's a contract for Amber Heard for the role of Mara in Aquaman and its sequels.
Which studio contracted with Amber Heard?
Warner Brothers.
When did you come to be the president of DC?
At the beginning of 2018.
Mr. Hamada, was Ms. Heard ever released by Warner Brothers from the Aquaman 2 contract, or what you call the option agreement?
No.
Was she released from her Aquaman 2 contract on or about February 22, 2021?
No.
Was Ms. Heard ever rehired for Aquaman 2 by Warner Brothers?
No.
Did Ms. Heard receive a pay increase for Aquaman 2?
No.
Why not?
As a rule, as a company, we go through a lot of trouble when we make our deals with our actors. We get options on them for subsequent movies. And I think traditionally, prior to me joining the company, every option was renegotiated. And one of the things that we were trying to put a rein in on was not renegotiating every deal, with the understanding that people come in and make these deals and they have an understanding that there will be options and that there is a deal in place. And it was a big part of our philosophy that we were going to hold people to their options moving forward.
But did Warner Brothers at any point in time reduce Ms. Heard's role in Aquaman 2?
The role in the film the size of the role in the film that she has was determined in the early development of the script, which would have happened in 2018, I would say.
Well,
So and from there, beyond normal development, the role the character's involvement in the story was sort of what it was from the beginning.
was her role ever reduced for any reason?
No, I mean, again, from the early stages of the development of the script, the movie was built around the character of Arthur and the character of Orm, Arthur being Jason Momoa and Orm being Patrick Wilson. So they were always the two co-leads of the movie.
Did Warner Brothers ever plan to portray Ms. Heard as the co-lead in Aquaman 2?
No, it was the movie was always pitched as a buddy comedy between Jason Momoa and Patrick Wilson.
Was Ms. Heard cast in Aquaman?
Yes, she was.
Was Ms. Heard cast in Aquaman 2?
Yes, she was.
Was Ms. Heard paid for her services in Aquaman 1?
Yes.
Was Ms. Heard paid for her services in Aquaman 2?
Yes.
Was her compensation for Aquaman 2 affected in any way by anything said by Johnny Depp?
No.
Was her compensation for Aquaman 2 affected by anything said by Adam Waldman?
No.
Was her compensation for Aquaman 2 affected by anything said by anybody representing Johnny Depp?
No.
Was there any delay in Warner Brothers exercising the option to cast Ms. Heard in Aquaman 2?
Yes, there was.
How long a delay was there?
I don't know, probably weeks.
What was the cause of the delay?
There were conversations about potentially recasting.
Who was the producer?
Peter Safran,
Who was the director?
James Wan.
Did Warner Brothers believe that those concerns were legitimate?
Yeah, I mean, I had no reason not to believe the director and the producer of the movie.
And you are testifying today as a representative of Warner, correct?
Yes, I am.
What, if any, creative concerns did Warner Brothers have about casting Amber Heard as Mira in Aquaman 2?
It was the concerns that were brought up at the wrap of the first movie, production of the first movie, which is the issue of chemistry. Did the two have chemistry? I think editorially they were able to make that relationship work in the first movie, but there was a concern that it took a lot of effort to get there. And would we be better off recasting, finding someone who had better, more natural chemistry with Jason Momoa and move forward that way?
Did Warner Brothers take any steps affirmatively to audition other actresses for the role of Mira in Aquaman 2?
No, we did not.
other than the creative concerns and concerns about chemistry you testified about, was there any other reason Warner Brothers delayed in picking up Ms. Heard's option for Aquaman 2?
No, it was all concerns about whether she was the right bit of casting for the movie.
What role, if any, did Ms. Heard's dispute with Johnny Depp have in Warner Brothers' delay in picking up Ms. Heard's option for Aquaman 2?
There was none from our end.
At any point in time, was Warner Brothers considering paying Ms. Heard more money for Aquaman 2 than is set forth in the option contract you previously identified?
No, as I said, we were determined to hold our actors to their option agreements.
Would Warner Brothers have paid Ms. Heard more money on Aquaman 2 if it had picked up her option earlier?
No.
At any time from the beginning of history through today, did Warner Brothers ever release Ms. Heard from the Aquaman 2 contract?
No.
At any point in time from the beginning of history to today, did Warner Brothers rehire Ms. Heard for Aquaman 2?
No, because we just picked up her option.
And when is the last time you spoke with Rob Cohen relating in any manner to whether to exercise the option on Amber Heard for Aquaman 2?
No, it would have been the same time that I was having those conversations with Peter Safran
So
in 2020.
Did you speak with Zack Snyder at all relating to whether to exercise the option for Amber Heard on Aquaman 2?
No, I've not had any conversations with Zack Snyder.
Did you speak at all with Jason Momoa in preparation for your deposition today?
No.
Have you ever spoken with Jason Momoa about any issues relating to chemistry between he and Amber Heard?
Yes.
When did you speak with Jason Momoa about chemistry issues between he and Amber Heard?
It would have been in that same time period where we were prior to green light of the movie.
Now, you were asked some questions about scripts. Did you review any of the drafts of the script for Aquaman 2?
Yes.
When?
Part of my role is I read all the drafts of the scripts as they come in.
When was the first script for Aquaman 2?
Oh, boy. I cannot tell you. Probably in 2018, the latter part of 2018 would be my guess.
And how many versions of the script had been written by the beginning of 2021 for Aquaman 2?
Oh, there were probably half dozen drafts of the script. Brought up.
All right, what, if anything, did Rob Cohen say to you about chemistry? What specifically about the chemistry between Amber Heard and Jason Momoa?
Just the fact that they didn't really have a lot of chemistry together. The reality is it's not uncommon on movies for two leads to not have chemistry, and that it's sort of movie magic and editorial, the ability to sort of put performances together, and with the magic of, a great score and how you put the pieces together, you can fabricate sort of that chemistry. And so I think at the end of the day, I think if you watch the movie, they look like they had great chemistry. But I just know that through the course of the post-production that it took a lot of effort to get there. Sometimes you don't. Sometimes it's very easy. You just put the, characters on the screen together and they work. And sometimes it's harder. And so...
Can you give me anything more specific about what it was with Amber Heard and Jason Momoa that was difficult for the chemistry?
No, because it's like what makes a movie star a movie star. Like you know it when you see it, and the chemistry wasn't there.
Now, you've used the term fabricated a number of times. What did you do to fabricate the chemistry between Amber Heard and Jason Momoa?
Well, those are just, it's editorial. A good editor and a good filmmaker can pick the right takes, can pick the right moments, and put scenes together. Again, score is a big, the music in a scene makes a big difference. It can make a happy scene feel sadder or a sad scene feel happier. And so it was sort of it's just the magic of post-production, editing, sound design, music, etc.
What do you mean by fabricating, though? I mean, were they literally falsifying, or were they just picking the best music? Let me finish my question. Were they picking the best music and picking the best looks because that's their job and that's what you do on every scene?
That is what we do in post-production. That's what filmmakers do. This is, on any production, you're doing that. You're putting performances together. Sometimes it's easier than others. This one was more difficult because of the lack of chemistry between the two. But they were able to, James Wan and the editor were able to get it to a place where the end result actually works. And it's great.
And in fact, that's the job of every filmmaker, right? Is to put all the combinations together to make the most successful production.
Absolutely.
I'll tell you what has been marked as exhibit number 5. It's ALH 18247. And this is a text message exchange between James Wan and Amber Heard. And you mentioned James Wan was the director of Aquaman 2. Is that correct? And
That's correct.
And Aquaman, the first one, correct?
That's correct.
All right. And James is texting to Amber on August 25, 2018. You rated really high with the audience, exclamation mark, exclamation mark. Do you see that?
Yes.
This is August 25, 2018. What's going on August 25, 2018 that would cause the director to send a text message to Amber saying,
That'd be a test screening. So during our post-production of movie, we test the movie with an audience, and the audience tells us what they liked and what they didn't like. And so that's what he's referring to there.
and they really liked Amber Heard, correct?
Yes, she did. She tested well.
It hit $1 billion, is that correct?
Yeah.
And more specifically, did you play any role in the determination to communicate to Amber's representatives that Warner Brothers was considering not exercising her option?
Yeah, probably in the sense of we had the conversations, and I believe, if I recall, we had that's where Peter Safran offered to reach out to the agent and express which direction we were leaning.
Have you seen any document that says there was any chemistry issues between Amber Heard and Jason Momoa in Aquaman 1?
Documents? No, I mean, those were all conversations.
But if Jason came back and James Wan came back, you were guaranteeing that Amber Heard would play Mira, correct?
That's correct.
Okay. And Jason Momoa was able to negotiate a different compensation structure, was he not, for Aquaman 2?
That's true. He did renegotiate.
Now, Aquaman was the highest grossing DC film ever for Warner Brothers, was it not?
Yes, it was.
And what, if any, issues did you have with Amber Heard in Aquaman 2?
My understanding is actually the production went very smoothly.
All right, thank you. Your next witness.
Your Honor, we call Dr. Colburn next, but I know we have a preliminary matter that we need to deal with briefly, if we may approach.
Sure. All right, ladies and gentlemen, I apologize again. We have a few things to take care of. We're just going to go ahead and take our morning recess now for 15 minutes. Do not discuss the case and do not talk to anybody, okay? Do not do any outside research. Sorry, that was the same thing. Take a break. All right, and if the doctor testifies, then is that WebEx? Okay, so I'll get that set up too while we take the break as well. All right, we'll go ahead and take a break. Let's make it 10:50 to give them time to look at everything, okay?
All rise.